Be live in 5, 4, 3, 2, 1.
This Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you, Mr. Hivner. Good morning, everyone. We are working through the January docket of oral argument cases here in Nashville, Court of Criminal Appeals for the Middle Section of Tennessee. My colleagues are from Columbia, Robert L. Holloway Jr., and from Williamson County, Judge Timothy L. Easter. My name's Robert Wiedemeyer. I'm from here in Davidson County, and we are grateful for the technology that's enabling us to operate during this pandemic and still hear oral arguments and dispose of these cases. We're continuing to do so as a court in a timely manner. And we're grateful to the Administrative Office of the Courts and the technology folks there who are helping us get this accomplished. And also to our clerk, Jim Hivner, and his staff, and our staff attorney who have worked hard to make sure this will happen by scheduling with the lawyers. I appreciate the lawyers' willingness to participate in this type of oral argument here. We're being live streamed through the AOC, and we as a court appreciate the attorney's willingness to do this. That being said, we will try to conduct the hearing today as close as possible to the way we would if we were in our courtroom. We have an excellent, beautiful courthouse down at 7th and North 7th in Charlotte, and hopefully we'll be able to get back in there soon. But because of the pandemic, we'll proceed in this fashion, and we will still have the normal rules, which basically allow for 20 minutes per side for oral arguments. However, in this case, because there are several defendants, we've extended that time to a total of 30 minutes for the appellants. And General Coleman, if you need a little extra time because of that, I'll certainly be liberal with you on your time as well. We have read the briefs. We're familiar with the cases that far along anyway. We have not been assigned the actual technical record to review, but of course we will eventually. Mr. Clerk, are there any other preliminary matters that you're aware of, sir?
Oh, Your Honor, there are not.
All right. Thank you. If you'll call the next case on the docket, please.
Yes, Your Honor. State of Tennessee versus Ronald Lyons, James Michael Usinger, Lee Harold Cromwell, Austin Gary Cooper, and Christopher Allen Hauser.
All right, thank you. Mr. Russ, are you ready to proceed, or Ms. Tennant? However you want to handle it.
Your Honor, I'll be going first. I'm Ben Russ. I represent Mr. Ronald Lyons. I would like to reserve 2 minutes of time for rebuttal, please. So when I get close to about 13 minutes, if you don't mind letting me know, I'd appreciate it. Ms. Tennant and I have discussed, and we will try our best not to be redundant, but obviously some of our issues will overlap. But of course, we would want to only talk about things once if possible for the court. That being said, I will try to move through the issues first that I think are pertaining particularly to Mr. Lyons, and then obviously some general issues related to forgery and things like that we'll both discuss, but in different aspects, I believe. The first issue that I wanted to address was that the state, in Mr. Lyons' case in particular, failed to produce witnesses in several accounts. Of course, the court said they were familiar with the facts of the case, but generally speaking, there were documents filed to the Secretary of State by various defendants purporting to have various amounts of money owed, mostly from public officials, law enforcement, things of that nature. In several instances in Mr. Lyons' situation, there was at least 5 witnesses that he allegedly forged documents or filed fraudulent liens against that never appeared in court during the trial. And I would say simply that the state has failed to present sufficient evidence that they are in fact victims of a fraudulent lien or of a forgery because there's no evidence in the record that what he filed or what he submitted, I think that might be an issue, but so I'll use the word submit, There's no evidence that what he submitted was in fact false or fraudulent because there was no victim, quote unquote, here by the state produced to substantiate that. So I think the state in the various counts, and again, since my time is limited, that's listed in the brief, and the particular people who are alleged victims are also listed in the brief. But I think it's important to note that, and again, I understand there was probably some 30 or 40 witnesses in this case, and then they're all mostly in Eastern Tennessee. But be that as it may, it's the state's burden to prove that these were in fact false or fraudulent, or they were forged. And we have no evidence from various witnesses that Mr. Lyons wasn't owed money by them. So I would say on those particular counts, and again, they're enumerated in my brief, the states have failed to present sufficient evidence for those particular counts. Briefly, to touch on the sentencing of Mr. Lyons, he was given a 22-year sentence at 30%. I understand these are A felonies. However, I could find no reasoning that would have permitted consecutive sentencing, despite the fact he was convicted of 60 different counts in this case. And in the absence of any ability to have a consecutive sentence, the maximum possible sentence the trial court could have given him was 25 years, and he received 22. He was a 60-something-year-old man at the time and had no prior criminal record. Obviously, none of these offenses are violent, nor do they threaten any kind of violence. And therefore, I think that the sentence of 22 years based on this is totally excessive. And I don't think the trial court used particularly strong or persuasive reasoning in arriving at the particular sentence that it found for Mr. Lyons. But the court is very familiar with sentencing statute. And as I think there's more pertinent things to get to, I won't belabor that. But I will say that considering that sentence is commensurate with people who commit second-degree murder, I just think it's excessive, and I don't think it was arrived at in the manner that the TCA prescribes. Moving on to the next issue that I thought was of particular importance, Mr. Burton was a representative of the Secretary of State's office that testified at numerous portions of the trial for the state, and his role was to introduce the documents that were filed by the various defendants in the trial and discuss the process of what the Secretary of State does in order to file these and then go through the technical aspects. There were numerous filings, and I've enumerated those in my brief, so I won't go over them here, but that Mr. Lyons submitted that Mr. Burton testified were rejected by his office. He said that one of their filters or procedures is that the person submitting the filing has to have a physical address that is valid in order for the potential person that the filing is submitted against can contest it. And in these particular counts that I've enumerated, there's approximately 15 of them. Mr. Burton's testimony, by my reading, was that these were rejected. And if no filing ever took place in the eyes of the Secretary of State at a minimum, then there's no way that a fraudulent lien or a forgery could have been filed under the meaning of the statute. And so again, I've laid those out, and I will point the court to TCA 47-9-516-B4, and again, I've cited that in my brief, which discusses effective filings, saying that a refusal to accept the record, a filing does not occur. Filing does not occur with respect to a record that a filing office refuses to accept because the case of an initial financing statement or amendment that amends or adds to a secured party of record, and the record does not provide a name and mailing address for the secured party of record. That particular statute sounds like it's outlining the exact procedure that the Secretary of State was using here. So on these counts that I've enumerated, I don't feel that the state has met its burden that a filing actually occurred because the Secretary of State, by their own admission, rejected what had been submitted by Mr. Lyons. Moving on to the next issue, would be one of venue, which is not one that I would often raise, but in this particular situation, it is pertinent. None of these cases, there were approximately 3 or 4 counties in Eastern Tennessee, mostly located near Knoxville, where the various defendants had taken these acts. And there was it's uncontroverted that none of them were in Davidson County. None of the alleged victims were in Davidson County. None of the actual filings physically took place in Davidson County. This was all done online via the Secretary of State's website. I would say that does not confer venue in Davidson County simply because the Secretary of State's main office is located in Davidson County. But more centrally to Mr. Lyons, the state never did any kind of election of offenses in this case. With the same counts of conviction that I've just mentioned that were deemed not to have been filed, I think this creates a venue problem for the state as to those particular counts, because if there was any act that took place that would have been violated of the statute, it necessarily did not happen in Davidson County, and venue would be improper. So on a separate but tangential theory, I think those same counts should be deemed to have insufficient evidence because the venue is lacking, because if it was not filed with the Secretary of State, then there is nothing that confers venue on Davidson County about these cases. And I would also argue that there isn't sufficient venue in the first place simply because the Secretary of State's main office is located here. If there are any questions, I will take them, but I would prefer to move on to my forgery argument, but obviously the court, I can answer whatever that may come to mind. I know I sprinted through that in order to preserve time on the other end. Seeing as that, my main argument here, and this, well, first of all, I would like to concur with an argument that Ms. Tennett's going to make in the near future about the nature of the documents that were filed, whether this ever actually created a lien or forgery, whether it can be deemed the same thing simply because that's what it was charged as. So I concur with her argument, but I will let her make it here in a moment. But I've cited various cases in my brief, and I've also cited Black's Law Dictionary, and this is parsing down. It's not splitting hairs. I believe that if we look at, well, first of all, I believe statutory interpretation is necessary here. Obviously, the state is proceeding under 3914B1B, which says that the making a false entry in a book or record is a forgery. This is the only possible avenue the state can have to meet their burden as to the forgery counts of conviction. I would say that this is not a false entry in a book or record, what Mr. Lyons and the other defendants did. I cited a couple of cases, Parrott and Pauley, that are from this court discussing what a false entry in a book or record would constitute. And those are having to do with account books and accounts of a company that then started sending out false accounts receivable and receiving checks for it in a fraud scheme. This is clearly not what we have here. I think it's clear that this is not what the General Assembly intended when they wrote the forgery statute, that this kind of conduct could be forgery. I think we see that in part because we have a separate offense for filing a fraudulent lien. There is an offense that specifically is tailored to the conduct of the defendants in this case, and that the state sought to expand or enhance their indictment by charging forgery, which I don't think the General Assembly ever intended. Secondly, and I've made these arguments in greater depth in my brief, if this was permitted to be deemed a forgery, if the court was to uphold this use of the statute by the state, it would expand the meaning, as I said just a second ago, of what the legislature intended when they were talking about forgery to something that's far beyond what had been intended when it was drafted. I think the most important argument, though, is the meaning of the word forgery. And I've cited this in my brief, but I'll say it again. In Black's Law Dictionary, forgery is the falsely making of materially altering with intent to defraud any writing which, if genuine, might apparently be of legal efficacy or the foundation of legal liability. And they also define false entry, which is a language that's in 3914.114B1B, false entry as an untrue statement in books of accounts that is made to deceive. So deceit and defraud are both used in both of those definitions that are central to this statute. If and when the court has the opportunity to read the entire record, I don't think there's any basis to show that Mr. Lyons in particular, but the defendants in general, had the intent to defraud either the alleged victims, who were mostly public officials, or the Secretary of State with these documents that they filed. And that is critical to the meaning of the word forgery, the intent to defraud. It's not simple. Without getting into too much, I think that these defendants felt wronged by various members of the government, and this was an effort to retaliate against these individuals. There was no intent that the state was able to produce on the part of the defendants to demonstrate that there was an intent to defraud by the filing of these documents or the submission of these documents. And that is central to what a forgery is. So to make a false entry in a book or record, again, the more specific definition suggests a book of accounts, but the more general idea behind forgery is that there has to be the intent that the writing has to be made with the intent to defraud the victim. And I don't think the state has, under even the most favorable evidence, showed that anybody expected to actually achieve what they were, the document being filed, and that it would achieve its purpose. The purpose was to retaliate or disrupt these people's lives because the defendants believed they'd been wronged. The purpose was not to get $5 million from various judges in East Tennessee or various law enforcement officers. So,
Mr. Russ, let me ask you a question. I was looking at 3914-114
yes.
A, and I see the intent to defraud, but it also has or harm another. What is your argument concerning harming these the victims of these people that had liens filed against them?
Well, my first thought on in that particular regard at harm would be a financial harm. I suppose that you could somehow, well, actually quite easily harm someone else in a financial manner without actually getting any money from them. And again, this statute relates essentially to financial crimes. So that would be my first answer to the court. But I also think, going to the more specific, to the false entry into a book or record, even if that portion of the statute is satisfied, I still think the other is not. I still think that this is not a false entry in a book or record as contemplated in the statute, but I would also argue that the intent to harm means an intent to harm them financially. And again, this in my mind was retaliatory, not take money from them. So that would be my argument as to that, Your Honor. I'm not sure exactly how much time I have left.
Mr. Rush, you are just into your rebuttal. So,
well, if there are no further questions specifically, then I'll just leave it at that and reserve the balance of my time for rebuttal, please.
All right. Thank you very much. Ms. Tennant.
Good morning, Your Honors. May it please the court. My name is Emma Tennant of the Nashville Public Defender's Office. I am appearing in the case of Mr. Christopher Hauser. I would like to reserve 3 minutes for rebuttal time, please.
Certainly.
Thank you. Your Honors, I would first like to address, as Mr. Russ stated, the law of forgery and why I believe the concept of a false making has survived the 1989 rewrite of the forgery statute. After I go through that, I'd like to drill down a bit into the exact nature of these documents, the financing statements, to review what under the law they actually are, what their legal import and significance actually is. I think that examination is going to be crucial to assessing their value if this court decides that they can in fact be forgeries. And finally, should time allow, I would like to address the issue concerning the labels put on some manila folders to house the exhibits at trial, and why referencing an amount, a filing amount on those labels constitute an improper and prejudicial comment on the evidence by the trial court. I will not likely have time to address sentencing, but will rely on the arguments set forth in my brief as to why Mr. Hauser's 20-year sentence is excessive. First, with forgery. Your Honors, the forgery laws were designed to safeguard confidence in the genuineness of documents, books, and records. The gravamen of the offense of forgery involves altering the authenticity and genuineness of writings, making them not, in fact, what they purport to be. A forgery, as Mr. Russ pointed out, requires a lie, but the type of lie is not a lie contained in the document, but a lie about the document itself. This concept of a false making is inherent in forgery, and although the words false making do not appear in 3914-114, I don't think you can examine a forgery without that concept in mind. It is what it means to forge. In a 1943 case called Mallory versus State, the Tennessee Supreme Court set out pretty thorough analysis of a distinction between a genuine making of an instrument with a purpose to defraud versus a false making of an instrument. Courts have over all time in all 50 states, in the federal government and in common law, drawn a distinction between forgery and obtaining property by a false writing. The genuine making of an instrument for the purpose of defrauding does not constitute the concept of forgery or the crime of forgery. Rather, in forgery, the instrument must fraudulently purport to be something that it is not. Mallory has been cited post-1989 to assess whether a document has been forged, what is and what is not a forgery. I do not think there's any evidence in the 1989 codification of forgery that suggests that they wanted to do away with all of the common law and decisional case law rules of interpretation of forgery. And I believe that this concept of false making has survived that recodification such that the instrument in a forgery must fraudulently purport to be what it is not. Here, the state agrees that for forgery to encompass the actions of the defendants in this case, we would have to decide that the legislature intended to expand and broaden the definition of forgery, so that in some cases, in the case of books and records, false entries made in books and records, it can be just a lie. But in all these other cases, under the 3914-114B1 definitions, it would require a false making. Again, there was no statement in the 1989 rewrite that explicitly stated they were abrogating common law meanings of forgery. And that common law meaning did entail the concept of false making. We can contrast that with the explicit statement made at 3914-101 regarding theft, where the legislature did explicitly state that they were subsuming all of the acquisitive conduct offenses into one simplified theft statute. That didn't happen with forgery. Again, Mr. Russ cited two cases, State versus Pauley and State versus Parrott. These are the only two cases I've been able to find since the 1989 rewrite that have examined the false entry in a book or record aspect or provision of the forgery statute. And in both of those cases, a non-genuine document became part of a book or record. So I would say that the way those two courts examined it, you did have a creation or an alteration of a document such that it became something other than what it purported to be. Other common law rules of interpretation have survived the 1989 recodification. One of them is the concept of legal efficacy. Legal efficacy is another forgery concept, which means that the document that's forged must have some possible legal effect. Basically, only certain documents can be forged, only certain papers can be forged. This court examined in State versus Finch, a 2013 case, whether or not forged receipts are susceptible, creating false receipts are susceptible to the law of forgery. And it found, yes, they could have legal efficacy based generally in the world and also based specifically in the context of that case. And therefore the defendant in that case was guilty of forgery. Legal efficacy does not appear in the forgery statute, but it is another common law concept that survived the rewrite. Thus, using the false making concept, we would submit that these financing statements filed by Mr. Hauser, filed by all of the defendants in the case, are what they purport to be. They are documents that they filed. They did not forge them in the sense that they signed anybody's name to them. A financing statement does not require a signature. The documents may contain a misrepresentation. They may contain a lie, but any lie in this case is not about the documents themselves. They are what they purport to be. They are the genuine financing statements filed by the defendants in this case. They remained, with forgery, with the way forgery is evaluated, they remained authentic documents. I'd like to move on into the value statement, and that's going to require me to drill down a little bit more into what financing statements actually are.
Let me ask one question generally, Ms. Tennant. Do the definition sections of Article 9 of the Uniform Commercial Code deal with these types of things, forgeries? I know they deal with financing statements, UCC1s and that type of thing. Was that brought up in this case? Did they use Uniform Commercial Code definitions at trial?
Well, Mr. Burton, Nathan Burton of the Secretary of State's office did describe the legal nature of financing statements. I don't think that they used any definitions. He talked about, for example, what collateral means and what the purpose of a financing statement is, but I don't believe that at trial any UCC code was actually discussed in front of the jury.
Was there any proof that a financing statement without a security agreement was in some way fraudulent or anything like that?
There is not proof of that. At trial, the court mostly looked at exactly what that document was. There's no proof at trial about an underlying security agreement needing to be there to give the financing statement any value, import, or significance. Mr. Burton did say that the reason we have financing statements is simply to put the world on notice that a security agreement might exist. But there was no specific testimony about what constitutes an underlying security agreement under the UCC or anything like that. I don't know if that answered your question. Okay. So financing statements, and forgive me, this does get a little bit tedious, but I do think it's really crucial that we talk about exactly what these are, because at trial, they were often discussed as being liens. They are not liens. A financing statement is not a lien. It's a document. It is a notice document. It is filed by a secured party. Well, let me back up. It is part of the law of secured transactions, and that is governed by Article 9 of the Uniform Commercial Code. It is codified in our laws, 47-9-101 at SEC, and that set of laws sets forth what a secured transaction is, and within a secured transaction, what a financing statement is. The purpose of a financing statement is to provide notice to others that a person may have a security interest in the collateral indicated. A financing statement does not need to include much information on it to perfect that security interest or to give the world notice of the security interest. The notice itself is simply one that this may exist and that further inquiry from the parties concerned, anyone searching a record, is necessary to disclose the complete state of affairs. As a notice document, the only things that need to be on there are the name of the debtor, the name of the secured party, and an indication of the collateral covered by the financing statement or the underlying collateral for the security agreement. There's not an amount on a financing statement. There's not a value on a financing statement. In its purest form, it just sets forth what the collateral is, the name of the secured party, and the name of the debtor. In Tennessee, we do have a recording tax that requires the secured party to state either on the financing statement itself or in an attachment the maximum principal indebtedness for tax purposes. At trial, Mr. Nathan Burton did testify that he believed that that maximum principal indebtedness statement would be roughly the value of the debt, the value of the financing statement. I'd like to back up from that and say, I don't think as a notice document, as simply a heads up to any searchers or would-be creditors, would-be subsequent creditors, that a financing statement has any value at all.
But isn't it notice to other creditors that the potential liability purportedly covered by this financing statement and some kind of security agreement that underlies it is up to the maximum amount of the indebtedness?
Because of some difficult interplay between the maximum principal indebtedness on the financing statement and on the tax in the tax statutes, really the UCC drafters would not want you to base any assumptions about indebtedness or the amounts of the loans on anything you see in a financing statement. In Tennessee, there's been there have been problems with courts finding under prior versions of the UCC and prior versions of the tax statutes, there have been problems with courts finding that a creditor could be stopped from collecting more on a debt if the maximum principal indebtedness noted for tax purposes was at one level, but there was actually further credit given to the debtor. And they wanted to just disentangle the taxing goal from the UCC goal. So those in the state's brief, he cited a few provisions to make it clear that that those provisions should not damage the perfection or otherwise harm what the notice. Oh, go ahead. I'm sorry, I haven't answered your question.
Apples and oranges. We're talking about
okay.
A maximum indebtedness to provide notice to third parties, to other lenders. And then we're talking about a contractual obligation between the borrower and the lender that can be based on the total amount, regardless of what notice you give to a third party. How are they related to this case?
Well, here, there's no indebtedness, first of all, because there's no underlying security agreement. The maximum principal indebtedness line was blank, and there were statements in the collateral description. I think when a searcher searches for records, searches through financing statements to perhaps give more credit to a debtor, they're just looking to see if that debtor already has obligations with regard to that collateral.
And if the debtor does and they don't make that loan, the debtor is harmed, correct?
Yeah, oh, for sure. I think that these financing statements can result in a sort of cloud on the debtor's title with regard to whatever's written in the collateral statement. I do think there can be harm done by way of credit delays or having to resolve paperwork issues with that. I don't have any problem saying that there is harm done by the filing of these financing statements. However, I do think that at trial, we talked very casually about an amount or a value of the financing statement. And I've been trying to work through what a value of a financing statement is. And I don't think you look to it by looking at words written in the collateral description. Oftentimes, when searchers search the records of the UCC, they don't necessarily even see what the collateral description is. They just see, oh, this debtor might have some obligation. So,
Ms. Tennant, you're right at you've got 3 minutes for rebuttal at this point. If you want to continue and use it, that's fine. You're obviously very familiar with the case and well prepared, and we appreciate the argument. But I know you mentioned you wanted to talk about the folders and the documents in the folders. So it's your call what you want to do.
If I could touch on that for maybe 1 minute, that'd be helpful.
All right.
So here, the state throughout the trial called the amount in the collateral description the amount of the lien or the value of the lien. And in organizing the file folders, the trial court just put that statement, what was contained in the collateral description, the dollar amount, put it on the folder as the so-called filing amount. In so doing, we believe that she adopted the state's theory of value. We had introduced a separate theory of value at trial through the testimony of Mr. Burton, through cross-examining him, and also in closing argument, that financing statements do not have a value. And if they do have a value, it would not be expressed through the collateral statement. If it's expressed at all, it would be on that maximum principal indebtedness line, 0. So we have a factual dispute as to what value means. And by the trial court putting on those folders, filing amount, the trial court adopted the state's theory of evidence that caused harm to our position and invaded the province of the jury. And if there are no more questions, I'd like to reserve the rest of whatever time I might have for the rebuttal. Thank you.
All right. Thank you. That's any questions from my colleagues at this point? All right, good. You still got your 3 minutes. And Mr. Russ, I think you've got 2 minutes left if you want to rebut. Wait a minute. I almost left you out. Sorry. Sorry about that. General Coleman.
Thank you, Your Honor. Good morning, Your Honors, and may it please the court, Ronald Coleman on behalf of the state. This is a somewhat complex case that dealt with 5 different defendants who collectively filed 102 liens against approximately 42 different individuals, mostly who were public elected officials. If the court has any question, I'm going to limit my argument today to the issues that were brought up by opposing counsels. But if the court has any questions on any of the other issues, I'd be happy to answer them.
Let me ask a general question so I'll understand the argument a little better. So when I was reading the briefs, it talks about a $12 million possessory interest in property of Buddy Bradshaw, the first one that's on there. So how did they determine it was a $12 million possessory interest if there's if the blank on there for maximum principal indebtedness on the UCC one was not filled out? Is that from the filing fees?
Yes, Your Honor. So there's a difference between the listing of the maximum principal indebtedness and between the listing of.
I'm sort of lost. Did y'all? I couldn't hear that, Mr. Coleman. If you could, I don't know if we were close to the microphone or what, but I lost that part.
My apologies, Your Honor. So there's a difference between the maximum principal indebtedness and the collateral description, and the valuation is listed in the collateral description. And so that's where it has who's the debtor, who is the creditor, who is the person that is being owed. And then there's a collateral description where it says, where the person who filed the lien said, I have a possessory interest of $12 million in the property of, Buddy Bradshaw or whoever the listed debtor was. And Mr. Burton's testimony, he worked for the Secretary of State, and he testified that these liens are records which go into the records of the Secretary of State. And I believe direct quote is that it puts the world on notice of this collateral possessory interest. And so that's where you get the valuation, is that when someone looks up whether someone has any debts or owes anyone else money, they will find this lien and see that, oh, this person owes $4 million or $8 million or $12 million to another individual. So that's where you get the valuation as listed in the collateral description. Does that answer your question, Your Honor? I hope that does.
I guess if the creditors had a possessory interest, why would they even need to file a UCC one?
Well, I think it's to put the world on notice. It's so that possessory interest is recorded. And that's what they did. That's Your Honor also referenced what sort of harm is done, and we had direct testimony from at least one of the victims who was formerly an assistant district attorney general, and she testified that when she went by the house, they looked her up and saw, oh, you owe someone else millions of dollars, and that it impacted whether she was able to buy that house. And so that's where the harm is. You've got this valuation of millions and millions of dollars. And I think kind of tangential to that and to your question is this maximum principal indebtedness section. And Defendant Hauser referenced that to talk about the valuation. But I think it's important to look at what the statutes are, what the legislature has said about this maximum principal indebtedness section. And really it deals with taxes and deals with only taxes and nothing else. In fact, Tennessee Code Annotated 67 409 emphasizes that the maximum principal indebtedness section, quote, shall not constitute notice of any kind to any other party of the amount of indebtedness secured by the instrument. So by statute, the maximum principal indebtedness cannot be the valuation of how much is actually owed. That only deals with taxes. And instead, in fact, according to Mr. Burton's testimony, this collateral description of what you own a possessory interest in is exactly what creditors and lenders look at when they're trying to determine how much someone owes or what someone's financial description is or financial status.
When we look at this record, will we see, particularly in the jury charge, law that was given to this jury from Title 67?
If the record will be more accurate than my recollection, but I do not believe that the jury was specifically instructed on that statute. I think I will note that Mr. Burton testified about the maximum principal indebtedness, and I can show you that is in volume 11, roughly page 424. So you can see Mr. Burton talks about this maximum principal indebtedness, and he said that that related to the indebtedness tax. And he even referenced Title 67. So the jury was made aware of this distinction between collateral description and maximum principal indebtedness. And Mr. Burton told them that what they did at the Secretary of State's office and what these financing statements did, that those two sections had different purposes. One described the value of the property or the collateral of the possessory interest, and one dealt with the indebtedness tax. And so the jury was entitled to accredit Mr. Burton's testimony and to find that this valuation or that the amount that was being claimed to be owned was.
Well, I know in cases of this nature where it kind of brings in the civil portion of the green books that normally we don't see during a normal criminal trial, it's not unusual for the defense or the state, for that matter, I guess, to ask that certain sections and code sections of particular volume of the civil code be read to the jury for guidance. Was any of that done here, or was it requested?
So my recollection of the record is that that was not the biggest area of discussion, and that I don't recall having any statutes or any portions of the UCC or any of that civil law actually being read into the record or being read to the jury. And instead, it was more of I guess you could call it a commonsensical argument to the jury of which section do you think establishes the value? And the jury was entitled to determine which section they felt established the value. And clearly they felt that the collateral description, which blatantly says, I have a possessory interest of at least $4 million in this person's property, the jury was entitled to accredit that as the valuation. So I guess I'll continue on the sufficiency arguments that we're talking about. First of all, I want to talk to Mr. Lyons' arguments. His first claim is that there were several witnesses who were victims who had liens filed against them that did not specifically testify, and that is correct. It's also irrelevant. Given the context of all of this information presented at trial, and the fact that I want to say at least 30 different victims did testify that they did not have any possessory interest they did not have any business relations with any of the defendants, that the defendants did not own any of their property or have any contractual dealings. The jury was entitled to find that this was like sort of a common scheme or plan, and to use the context clues and the circumstantial evidence to find that these other victims also did not have business relations with the defendants, and that the defendants made a false entry into the record, and that they did not have any reasonable basis to file this lien. And so the jury was entitled to use this circumstantial evidence and just the context of the overall trial to find the defendant guilty of those offenses.
The alleged victims, or the victims that did testify, did they testify as to the value of the harm that was caused to them because of this?
I don't think they specifically testified about any harm except for two witnesses. One was the former ADA, whose name escapes me for some reason. She testified that she went to buy a house and that she had difficulty buying that house specifically because of this lien. And then another witness was Ms. Hauser, and she testified that she had difficulty based on a lien that was filed against her. And so I think you have proof of harm, but you don't actually need that for either the forgery convictions or the fraudulent filing a lien convictions. Instead, what you have to establish is the intent. For forgery, you have to establish the intent to defraud or harm someone. And the jury could find that by filing these financing statements, which purported at millions of dollars of interest, that the defendant at least had an intent to harm. In fact, I think Mr.
I understand that, but you still have to, in a forgery case, establish value for determination of class of felony. Do you not?
Yes, Your Honor. And that valuation was established through Mr. Burton's testimony, not through the victim's testimony. I think it would be difficult to find that these victims suffered were out of pocket millions of dollars. Instead, the harm was that they essentially were listed as owing millions of dollars. Their financial credit and that their financial solvency had gone down millions of dollars based on these financial statements. And the jury was entitled to determine that once these financing statements were filed, that those financing statements had a valuation of making these victims owe millions of dollars. So I think you've got this valuation, you've got that the jury can find these different that every single victim was in fact a victim. I'd like to talk about the liens reportedly being rejected, and this kind of bleeds over into the venue argument as well. But we need to look at Mr. Burton's testimony a bit more specifically, and I encourage this court to look at these specific exhibits that deal with the liens that Mr. Lyons is arguing were rejected. Because in fact, what happened was they were filed. You can see a file stamp to date on them. And what Mr. Burton testified that happened was once these are filed, the purported debtor gets a notification that should be sent by the defendants. The defendants actually did send them to the victims, but the victims can contest that lien and say, no, I don't owe this. This is wrong. This is false, and I don't owe it. And what happens then after it's being contested, the Secretary of State's office will send a letter to the purported debtor or the purported creditor and say, hey, this is being contested. You need to provide proof that this is being owed. And what would happen here is that those letters would get returned as undeliverable. And once it got returned to the Secretary of State's office, that's when the liens were subsequently voided. But they were nevertheless filed. And so that meets the statutory element of filing for both for all of the offenses. And so that's simply an argument that has no merit. Even if they were subsequently voided, they were still filed. And so I think that's important. Mr. Lyons also argues that there was no book or record here. The fact that these are public records should not take away from the fact that they are the records of the Secretary of State's office. I understand this doesn't normally happen. This isn't a typical case that deals with books or records. Normally, that's some sort of accounting book, a private firm, or something of that nature. But the Secretary of State's office also has records. And those records, there were false entries into those records based on these financing statements. And so that meets the the plain language of the forgery statute. The definition of forgery is a false entry into a book or record. And because you have the Secretary of State's records, these were false entries into them, and it meets the statutory definition. Finally, Mr. Lyons argues that there was no intent to defraud, and that's simply a jury determination. And I think he actually conceded that this could cause financial harm and that the purpose was, in fact, to disrupt these individuals' lives. And so I think that establishes the intent to defraud or to cause harm to these victims. When you couple that to the several witnesses' testimony that they were, in fact, harmed, the jury could find that there was an intent to harm or to defraud these victims, and that jury has determined that, and we would ask this court to simply uphold that jury determination. Moving on to Hauser's arguments, the first argument is that he attempts to distinguish the genuineness of a document versus the genuineness of the information contained therein. And if the state had proceeded under section 114B1A, we would actually probably concede that subsection specifically focuses on the genuineness of the document. But the state proceeded under subsection B1B, which deals with a false entry into a book or record. The book or record itself can be genuine. The question under subsection B1B is whether the entry, whether the information is false. And here, the jury was entitled to determine that this purported possessory interest was in fact false, and that statutory element was met. That in fact, the defendants, by filing these financing statements with false information, made a false entry into the record. And so this distinction between the genuineness of the document versus the genuineness of the information it just simply has no merit when we're proceeding under subsection B1B. Mr. Hauser also claimed that these financing statements for their valuation, I don't want to beat the dead horse here, but they talked about some possible legal impact or the legal relevancy of it. And again, the ADA testified that she was prevented from buying a house, or she had encountered difficulties from buying a house. And Ms. Hauser testified that she encountered difficulties based on these liens. So certainly, each of these liens, were they to be looked at, were one of the victims to attempt to buy a house or to do something that involved a credit check, these certainly had the potential to impact that credit check or that action. I think the last thing I would like to go, or two more things. One, the folders. The defendant claims that the trial court erred and improperly commented on the evidence by attaching a sticky note to the outside of a folder with the relevant information that was contained inside in those exhibits. And so I think it's important to note that there were 102 exhibits that were made, that were entered into the record in this case. They totaled approximately 1,500 pages. And so what the trial court did was to organize each exhibit into a manila folder and then put the identifying information on the outside. The state encourages this court to simply look at those folders and that sticky tab and to look at it. And this court will see that it is not an improper comment on the evidence. It does not.
Was there an objection made to that procedure?
Only Mr. Hauser made an objection to that, and the court respectfully overruled that objection. The court said, "I'm just trying to make this easier for the defendants, and I'm not commenting on the evidence." And when this court looks at the record, it will see that this is not a comment on credibility or the weight of the evidence or anything that would be an improper comments by the trial court. And even if this court were to disagree, it does not rise to the level of reversible error based on the totality of the circumstances that occurred at trial. When this court examines the record and sees all of the proof that was presented, and especially Mr. Burton's testimony regarding the valuation, the trial court's sticky tab note was not an improper comment, and certainly was not so prejudicial that a reversal is warranted. And lastly, I'll go to the sentencing claim by Mr. Lyons. The trial court here, for every single defendant, stated what its considerations were, considered the relevant factors, put on the record the applicable enhancement and mitigating factors. And it's important to note the trial court did find both enhancement and mitigating factors here, and then concluded that the appropriate sentence was, for Mr. Lyons, I believe it was 21 years. This was a proper exercise of its discretion. It gave a within range sentence after finding appropriate enhancement and mitigating factors and after making the appropriate considerations. And so the state respectfully asked that this court not only affirm the sentences, but affirm the judgments of all of the convictions. Unless there are any further questions, Again, we ask that you affirm the judgments. Thank you.
Thank you, General. Now we're to rebuttal time. Mr. Russ, you want to go first?
I will, Your Honor. Just briefly to address as quickly as I can a couple of the things the general said. If I'm understanding the state's argument, if other victims of other counts establish all the elements of the offense, then it's okay for the jury to presume that that happened too for other victims that didn't present any evidence or establish all the elements of the offense. So I disagree.
And I don't know exactly how to frame it. Does it talk about intent to harm as opposed to actual harm? Does the statute?
Well, I was referring to the witnesses that didn't appear, but as far as the harm, it just, if I had it up here on my computer, Your Honor, just 2 seconds ago. All it says is with intent to defraud or to harm another. It doesn't specifically reference that intent is applied to just defraud or just harm or both. So to address the issue of harm, as the general said, I don't think there was more than a couple of people, and I guess Mr. Hauser's wife was one of them. So Mr. Lyons had nothing to do with that particular incident. All of these people that had these documents filed against them, they were ultimately taken off. I believe almost all of them had it done free of charge since they were public officials by the Attorney General's office. And almost none of them talked about any negative repercussions that actually took place because of these documents being filed. So I don't think that, that harm had occurred based on the discussions that we've had here today. And also just in response to one of the general's arguments, I guess the state's saying that if a Secretary of State or a clerk's office takes something and stamps it, and then whoever later determines that that was an improper filing, that still counts because they then did their diligence and decided that it, despite having a stamp filed mark at the top, was not actually a proper document that should be recorded or filed or whatever you want to call it. So I fail to see why diligence doesn't negate a stamp file. So I don't think the state's argument there saves them against the argument that I've made. But, more centrally to the court's question about whether there was a harm caused, no, I don't think there was harm caused to the vast majority of the alleged victims here, at least not as to what the record recounts. And again, I would simply, I'm sorry, Judge.
You have two witnesses that testify as to actual harm.
I believe that's correct. Again, there were some 35 to 40 witnesses. It might have been more, but it certainly was few in number.
So could the jury then infer that they intended to harm those two victims and without proof of actual harm infer that they intended to harm the other victims also?
Well, that respectfully, no. I mean, then you're getting into a lot of leaps here that, absent any actual evidence establishing harm, but to these 2 of 40 people, can we infer that they were trying to harm the other people that just didn't succeed? Would that be an attempt instead of the completed offense? I don't think that I think the record, what the state needed to establish through the witnesses that they brought. I mean, again, to take it one step further, could the jury infer that a witness who didn't appear to say that there was no legitimate debt, then the jury could infer that there was no legitimate debt absent that testimony, and there was intent to harm absent any testimony from that witness as well. So I think once you go down that road, I don't think this is meeting the burden statute requires of the state beyond a reasonable doubt. And I don't think it's simply a jury issue to determine. I think there's a deficiency of proof rather than simply a question of proof. So.
All right. Thank you, Mr. Russ. I think you're out of time. And Ms. Tennant, you've got 3 minutes if you want to have a rebuttal argument.
Sure, I'd like to address a few points made by the state. First of all, the state calls this interest that the interest relayed on the financing statement is a possessory interest based on both the UCC and the testimony of Mr. Burton. It is not a possessory interest. It is a security interest. And he explains that that statement puts the world on notice that the creditor may have an interest in the collateral used to make the loan. And that is at volume 966. He later defines collateral as the asset or item that the secured party is trying to perfect an interest in by filing a financing statement. Again, that's a security interest, not a possessory interest. I don't think the phrase possessory interest came up at trial. He also defined value at one point as the submitter's evaluation or valuation of what the document might be worth, pointing to that maximum principal indebtedness statement. So again, collateral is something standing aside the loan. The maximum principal indebtedness might indicate the amount of the loan. But here's the thing, under no point in a financing statement, other than this quirk of tenancy law regarding the recording tax, is there a need to reference the amount of debt at all. Going to the folder issue, Your Honors, we did object at trial. We did call it a comment on the evidence. We did submit other proof of how the jury might determine value. And the trial court stated simply, no, the amount is listed on the financing statement. It's the financing statement amount. You can argue all you want to about the value of it, but with the financial, what the statement says is the amount. And I would just say that that has adopting the state's theory of value, which is contrasting with this theory of value that the defense through Mr. Hauser presented at trial. If there are any further questions. Thank you.
All right, thank you very much. All three of the attorneys, we very much appreciate the arguments and the briefs are excellent. The arguments and briefs will help us a great deal as we try to decide this case. It's far from a run-of-the-mill criminal case. So we'll take it under advisement and get an opinion issued as soon as we can. And that concludes this case. Mr. Hivner will be in recess until 1 o'clock.
Honorable Court is now in recess until 1 p.m.